First District Court of Appeals, 9 session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have two cases on the docket scheduled for oral argument this morning. Our first case is David Donaldson versus State of Florida. May I approach counsel? Mr. Elfman, we reserved 15 minutes per side for the oral argument this morning. Would you like to reserve some time for rebuttal?
Yes, Your Honor. 4 minutes, please.
So noted, Madam Clerk. You may proceed, Mr. Elfman.
Thank you. Good morning. May it please the court. Michael Elfman on behalf of the appellant David Donaldson. I'm hoping to focus my time on the first issue raised in the briefs, and then I hope to also briefly address the second issue. The first issue concerns whether or not the trial court in this case erred by giving the aggressor jury instruction. And let me cut right to the chase. I believe the issue in this case comes down to whether or not the statement that we could take it across the street, we could handle it like men and take it across the street, amounts to the threatened use of force. Before I address that, though, let me jump into the two prerequisites that are a requirement to give the aggressor instruction, which is 3.6F. And 3.6F says that the aggressor instruction should only be given if applicable, meaning there must be some evidence in the record to support giving it. And the two alternative, or not mutually exclusive, but two bases that a trial court could find would justify giving the instruction is if there's evidence that the defendant actually used force or the defendant threatened the use of force. Let me quickly address the actual use of force, because I think there's some argument back and forth in the briefs about whether or not my client's actions amounted to the actual use of force.
But that said, though, counsel, wasn't there a factual dispute as to whether the appellant may have initially provoked the use of force against himself?
Was there a factual dispute?
Yes.
I believe there's not. And I think there's only two eyewitnesses to this case, and they're both state witnesses. So if you put aside completely everything my client said, and I've acknowledged that that's what should be done for both of these issues, but certainly for the first issue, you still have to focus on the two state witnesses, and those are David Ortiz and Jason McCullough. They both said that this incident began when my client was installing some AC equipment at a construction site. The alleged victim in this case, Mr. McKinney, was not happy with the way that was put in, and then he ultimately ordered my client to leave the site. So my client then leaves the construction site, goes outside to his truck, and he's outside in his truck, and at that point, Mr. McKinney is on the phone with someone, and he refers to my client as a pansy. My client obviously hears that by his truck, and that's when he makes the statement that he wasn't going to be too much of a pansy, that they could handle it like men and take it across the street. But the evidence is there's no dispute between Ortiz and McCullough. They both say that at that point it was McKinney who speed walks towards my client. And McKinney is the one that initially approaches my client, and McKinney is the one that first uses physical force against my client. No dispute in the record that my client in any way started the actual physical use of force, which is why I started with saying that there's no actual use of force by my client in this case initially. Of course, he responds and obviously ends up shooting Mr. McKinney, but that's irrelevant for whether or not my client was the initial aggressor or provoker of the force in this case. So I think that's why it all comes back to this statement. We could take it across the street. We could handle it like men and take it across the street. Does that amount to the threatened use of force? And I submit, I think the standard is a reasonable standard, an objective standard. And I think if you objectively look at that statement alone, it simply doesn't rise to the level of what's required to be a provoker under our statute or under our jury instruction that would justify giving this instruction. There's a couple things about that, and I rely upon what defense counsel below said. It's not like my client said, I'm going to attack you, or I'm going to kill you right now, or I'm going to shoot you. He said, we could take it across the street. Of course, they never did take it across the street. It was McKinney who approached my client right then and there at the truck, and it was McKinney, the record shows, that he said he wanted to fight right then. I think the exact words were, he speed walks, and we don't have to go across the street. Like, no, we can fight right here and now. That's what McKinney says. But my client's statement was a conditional statement. If we go across the street, it's almost like, if he would have said, we can handle this later, let's go meet at the boxing ring, or maybe I'm dating myself by using a boxing ring. Maybe today people would say we go to a cage and engage in some type of MMA fight. But of course, my client didn't then go across the street. He didn't go to where he said we could engage in this physical confrontation. He stayed right there at his truck, and it's McKinney who approached my client and provoked the incident by starting the fight, by having the initial physical contact with my client, by initially saying, we can fight right now. We don't have to take it across the street.
Counsel, from your recollection, how exactly did the state use the initial aggressor instruction in closing? Did they say that, look, the mere fact that he said words is enough to make him an initial aggressor and therefore not entitled to use self-defense?
I don't know if the state said that, Your Honor, and I don't know if I can...
well, then how did they use it? How did it come up?
Obviously, it was the instruction that was given, and I think the reason that it's so harmful to my client is it's not an instruction that's given in every case. So it's not a situation where you simply say, oh, we'll let the jury decide whether or not there's evidence in the record to show that he's a provoker, and if they conclude that he was, then they'll properly apply the instruction. No, you only give this instruction if there's evidence to support it. And the reason it's so prejudicial to a defendant who's claiming self-defense is a couple things. Number one, obviously we have stand your ground in Florida. So my client, if this instruction is not given, the judge did instruct the jury initially that my client had no duty to retreat. But by giving this instruction, the court then tells the jury that if they find that my client was the initial provoker, which again, if there's no evidence to support that, I don't think we can rely upon the jury to try to figure out what that may or may not mean. It's a confusing instruction when there's no evidence to support it. And if they find that he's the initial provoker, then he's not justified in his use of force.
That's kind of what I was getting at, though. If there was, it's hard for me to necessarily see what the harm is in the use of an improper instruction if there's no evidence to support it. That's why I asked, did the state somehow use that instruction to imply an incorrect legal standard with regard to whether or not he was an initial aggressor and that they should reject a self-defense claim because he was an initial aggressor?
Sure. I believe the state, and I may have to refer back to my record and answer that better in rebuttal, but I believe the state did in fact argue to the jury, you should find that he's the initial aggressor and therefore he's not entitled to use of force. And again, by making that argument, then because the jury was instructed this way, the instruction specifically tells the jury that my client's not justified in the use of force, and of course he did use force, there's no dispute about that, and that he would have been required to escape the danger or withdrawal. We know that that didn't occur. So in essence, by giving this instruction when there's no evidence to support it, the jury had no other option but to find my client guilty. His self-defense is out the door by giving this instruction. So a couple other arguments, again, that were made by defense counsel below. In essence, this is an invitation to, in the future, engage in mutual combat. He was basically saying, if you have a problem, you can fight me. It's no different than trash talk or locker room talk. And this is what defense counsel specifically said. Let's take that characterization, inviting someone to engage in mutual combat with you without an overt act that puts them in imminent fear that you're going to use force against them. You're not the aggressor. You're not the provoker legally. So again, we simply don't have objective evidence that my client, and again, I think the only thing in the record that anyone could point to is his statement that they could handle it like men and take it across the street. Of course, my client didn't thereafter go across the street. So based on that alone, and based on McKinney's actions thereafter, there's simply not reasonable objective evidence in this record for the court to have given this instruction. And again, I believe it was harmful. Once it's confusing, and I've cited to the forcible felony cases in my briefs, once you give that type of instruction, if there's no predicate for it, then the jury is left with these alternative conflicting instructions. On the one hand, he has the right to meet force with force and stand his ground, but on the other hand, he's not justified, and he has to withdraw or escape. And again, we know he didn't do that, so that's why the state can't meet its burden. That again, if the court concludes that I'm correct and this instruction should not have been given, the burden shifts to the state to show that there's no reasonable possibility that this instruction would have influenced the jury to come back with this guilty verdict. And I submit, again, based on this facts, based on the fact that these instructions would, again, conflicted with each other, would have negated each other, my client's self-defense would have been completely vitiated as a result of this. The state can't meet its burden of proving beyond a reasonable doubt that this is a harmless error.
Counsel, as to your second issue on appeal, The appellant argued in moving for a judgment of acquittal that there was insufficient evidence of ill will, hatred, spite, or an evil intent so as to preserve his second claim of error on appeal.
Is it preserved? Is that what you're asking, Your Honor?
Correct.
I believe it is. I mean, I think he cited to the cases that I'm citing to in my briefs that when you have an impulsive overreaction in a situation that erupts very quickly like this, that there certainly are courts around the state that have found that that doesn't rise to the level of second-degree murder. That's merely manslaughter. I obviously cited to the Henry case, which cites to itself a number of those cases. I think the best of those cases is the Dorsey case, which in Henry quoted Dorsey as saying that evidence was insufficient to support second-degree murder conviction where the defendant, after being confronted by a number of heavily intoxicated men and punched in the face by the victim, impulsively overreacted by shooting. I think that almost that's on all fours with the facts of this case. You have my client, obviously he argued self-defense. I'm not raising that issue on appeal. I clearly acknowledge that that's an issue that's a jury question. But again, there's numerous courts around this state, and it's splitting hairs. It's not, there's some cases that support one argument and some cases that support the other. But there certainly are cases that say that in this situation, where they don't have any previous history, their history began just that morning with the McKinney complaining about the work that my client was doing, kicking him off the site, and then it immediately erupts. Again, there's no dispute in the record that McKinney is the one that physically confronted my client first, that when my client grabs a gun and shoots him in response to that, the jury disregarded his self-defense claim, but there's certainly evidence, or there's certainly a strong argument that that doesn't rise to the level of second-degree murder. That is the classic impulsive overreaction that would justify, in this case, only a manslaughter conviction. Obviously, my client was convicted of second-degree murder and is now doing a life sentence for that. And I think that's something that can be taken into consideration.
Counsel, you are into your rebuttal time.
Thank you. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel.
May it please the court?
You may
Counsel?
proceed, Mr. Lawton.
Thank you, Judge. Zach Lawton for the state of Florida. I want to talk first about Issue 1 and then Issue 2. The question presented in Issue 1 is whether the trial court abused its discretion when it gave the same jury instruction that was requested but not given in Gibbs. That instruction was, the use or threatened use of deadly force is not justified if you, the jury, find that David Allen Donaldson used force or the threat of force to initially provoke the use or threatened use of force against himself. The case law from this court establishes that the instruction is to be given if the defendant may have initially provoked the use of force. Now, there are two questions here, whether there was error and whether the error was harmless. I want to start with the first question. The state's answer is that there was no error in giving the instruction because there was evidence that Donaldson may have been the initial aggressor.
Counsel, would the invitation to fight by itself be sufficient evidence that an appellant may have initially provoked the victim's use of force against himself?
I think the answer to that question is probably no, but I think it's important to look at the entire context here. We have evidence. We have two witnesses who say they saw Donaldson up on the ladder and they could, his hands were raised, he's working on the AC, and they didn't see a gun. They didn't see a holster or a gun in his waistband. And then we have the argument about the scratches on the roof. He's told to leave. We have evidence from Mr. Ortiz that Mr. Donaldson goes to the truck, leans into the truck, messes with something, and then he comes back out. And both McCullough and Ortiz are on the other side of the truck, so they can't really see what's going on with his hands. But he comes out of the truck. He steps toward Mr. McKinney, and there's evidence there. I believe the jury could fairly conclude that he had gone to his truck to retrieve the gun, and now he's stepping toward Mr. McKinney. He says either Mr. McCullough's statement was that David said he wasn't going to be too much of a pansy, and I believe Mr. Ortiz said, who you calling a pussy? Now, take all that into consideration, and it's clearly an aggressive move by Mr. Donaldson to walk toward Mr. McKinney, potentially with a gun in his hand, making those statements. So that combined with let's take this across the street, I think is more than just mere words. It's certainly conduct. It's certainly a threat of force.
Was it enough for Mr. McKinney to act in self-defense for what Mr. Donaldson was doing?
Well, I certainly think so. We have a clear threat of force that provokes Mr. McKinney's actions. He drops his, he's holding a notebook, he drops that, and then we have the testimony that he speeds walked toward Mr. Donaldson, but he's not speed walking toward him with a fist raised trying to attack him. He's going for Mr. Donaldson's hands, is what the evidence indicates, trying to push Mr. Donaldson's hands down. That's a defensive move. That's not initiating a fight. That's probably trying to get the gun pointed down at the ground or get it from him so that he doesn't get shot. So I believe that was provoked by Mr. Donaldson's actions that preceded it. And of course, the instruction does not say it has to be the use of force. It's the use or the threat of force. So we have a threat of force that provokes Mr. McKinney to act in self-defense, and then that's followed by the actual shooting.
You may have touched upon this with your answer, counsel, but again, what evidence was there to support a jury finding that appellant shot the victim with ill will, hatred, spite, or even intent instead of as a mere impulsive reaction during their fight?
Yeah, well, I have 4 reasons for that. First, I believe the case law supports this, Mr. Donaldson's act of retrieving the gun in response to an argument is an act of enmity. He's certainly raising the stakes there. It's one thing if the jury believes that he already has a gun on him, and that's a different issue. But if the jury believes that the evidence that Mr. Donaldson was not armed while he was doing his work, and then he goes to his truck and he comes out and now he is armed, and that's in response to an argument. That's not in response to a threat. And I believe that would be showing enmity. My second answer would be clearly Donaldson appeared angry about getting fired from the work site, and the allegations of sloppy work and also being called a pansy. And then my third answer is that the evidence seems to indicate that Mr. McKinney was actually shot in the back, and so the first shot disables Mr. McKinney's right arm, and then he's shot in the back. And I would say that second shot seems to show an intent to kill. It's not, he's no longer trying to neutralize the threat. He's at that point, that's showing ill will. That's an attempt to kill. And then my fourth reason is that his actions after the shooting, and the case law bears this out, his actions after the shooting show, it would be akin to consciousness of guilt. He doesn't shoot Mr. McKinney to stop the threat and then go, oh, whoa, what just happened? And now Mr. McKinney's obviously no longer a threat, and he doesn't go render aid, call 911. Instead, he turns to Mr. Ortiz, points the gun at him, and I believe the testimony was it was about a foot from his face, and he says, you want some of this too? And then he leaves the scene. And that's, I believe that shows after the fact that he had been acting in ill will, not out of, it was not an impulsive overreaction that was part of his self-defense.
Gus, let me go back to the first issue. Now, of course, initial aggressor is an exception, right, to self-defense. In other words, even if you are clearly acting in self-defense, you're not entitled to the defense if you were the initial aggressor. So if we were to find that there was no evidence to support an initial aggressor instruction, was he acting in self-defense sort of as a matter of law? Is that clear from the record that he was acting in self-defense? I guess in a way I'm asking whether there was any harm to the giving of the instruction even if there was no evidence to support it. That's two questions.
And the question is whether there was no evidence to support the self-defense claim? The
self-defense claim at all, irrespective of the initial aggressor instruction.
Okay, I think Mr. Donaldson's testimony would support the self-defense claim. Obviously, the state doesn't.
So it can't be harmless then?
Well, it could still be
giving of the
harmless.
initial aggressor instruction can't be harmless because if that erred, then he was in fact acting in self-defense. Did I make that clear?
So I think my reason that I believe it's harmless is that it's not a confusing instruction. The cases, if you look at the cases on forcible felony, those all talk about how it's circular logic and it's confusing. And if the instruction basically says if you were doing this, you don't get the self-defense. And so it's a problem in just the way that instruction is written. This instruction is very simple. It says if he was the initial aggressor, then you apply the initial aggressor instruction. If he was not the initial aggressor, you don't. And we assume that juries follow the instructions as given. And so the jury hears the instruction that if he's the initial aggressor, then I'm going to apply this. And if the evidence is there, they apply it. And if the evidence is not there, they don't apply it. So I believe that's what makes it harmless. I'm not sure I don't think a correct statement of the law would be a problem if just because there is evidence that Mr. Donaldson said he was acting in self-defense.
No, I agree. I think that it's kind of a problematic comparison to the forcible felony when that's given incorrectly. But what I'm worried about is if we were, I'm going to say we will, but if we were to find that there's no evidence to support the initial aggressor instruction, I can't understand how it could be harmless, because if not, then he was in fact acting in self-defense as a matter of law. And if I understood what you said, there's really no evidence that he was not acting in self-defense. In other words, the jury had to either find that he was the initial aggressor or not.
Well, I think the jury could find that Mr. McKinney's action of going for the gun was purely defensive. And I think that would show that it was not self-defense. I think I misunderstood your question originally. I believe there is evidence that Mr. Donaldson says he was acting in self-defense, but there's also evidence from which the jury could conclude that it wasn't self-defense at all.
Could reject it.
They could completely reject the self-defense
irrespective
claim.
of initial aggressor. They could have rejected self-defense.
I believe that, Judge.
So that in of itself may be why it's harmless, in that even if it was a mistake to give that instruction, the evidence shows that he didn't act in self-defense anyway.
I would agree with that, Judge.
And what evidence is that?
The evidence would be the evidence that Mr. Donaldson is completely acting, Mr. McKinney is completely acting defensively when he goes for the gun. There are kind of two options. If somebody draws a gun on you, you can try to run the other way, get out of range, or you can try to neutralize the gun. But obviously standing there and in a defensive posture is not a way to combat somebody with a gun. So if the jury believed that Mr. McKinney's action had nothing to do with trying to attack Mr. Donaldson or harm him, that he was simply acting in self-defense by trying to neutralize the gun, then which the jury certainly could conclude that, because they know there's a gun there, even if none of the witnesses can see it, and they know Mr. Donaldson is going for the hands, which is very much not an aggressive maneuver. Going for the hands is defensive, I believe. Then that would be how the jury could conclude that there was no self-defense, regardless of the initial aggressor instruction. And also, I think it's also relevant to this issue that his actions after the fact. I think the fact that Mr. Donaldson turns to Mr. Ortiz and puts a gun in his face, says, "You want some of this too," and then doesn't render aid and leaves the scene. I think that shows, like I said, something akin to consciousness of guilt, and the jury could hear that and think that's not the actions of someone who just acted in self-defense. That's the action of somebody who, is in a very aggressive frame of mind. And the other issue we haven't talked about was the delay. I think the delay is pretty important as another reason the jury could believe that even if the jury believed that Mr. McKinney was the initial aggressor when he speed walks toward Mr. Donaldson, we have a gunshot, and That's the gunshot that hits Mr. McKinney in the shoulder and completely disables his arm. And then we do have a delay. Mr. Ortiz originally says it was a couple of seconds between gunshots. Then later in his testimony, he says, let's see if I can get the quote here. It wasn't 1-2 like a double tap. It was pop, pop. And the way it reads in the transcript is pop, comma, pop. And certainly the judge and jury were in a position to know how he said it. Did he say pop, pop, or pop, pop? We don't know. We just have what's in the transcript. But the judge and jury would be able to hear that. And so if there's a delay between the two gunshots, and during that delay, things happen. According to Mr. Donaldson, that was when Mr. McKinney went for the gun again, I guess with his good arm. We also know that if Mr. McKinney is speed walking the length of a truck, a pickup truck, a work truck, that's not going to take very long. And if he's shot the first time in the shoulder, and then we have a couple of seconds between shots, he should be right up on Mr. McKinney at that point. I mean, Mr. Donaldson at that point. But because of the soot and stippling evidence, we know that he was not within, or at least the jury could believe, he was not within 3 feet of Mr. Donaldson at the time of the second shot. And he's also apparently twisted around or his back is facing to him.
What evidence supports the argument that he was not within 3 feet of Mr. Donaldson at the time of the second shot?
Right, and so that would indicate that...
What evidence supports that argument?
The soot and stippling evidence that, let's see, Dr. Radke talks about, that it would have been on his clothes had he been shot within 3 feet. And so if he's stopped by that first shot and he's no longer... He has plenty of time to get to within 3 feet of Mr. Donaldson. And so the fact that the second shot still doesn't have the stippling would show that he hasn't made it that far yet. And so that would show that there's something has happened, some sort of change has happened during which Mr. McKinney may have thwarted, tried to go off the attack. He may be on the ground. We don't know exactly what happened, but we do know that there's a delay, and then Mr. Donaldson chooses to shoot that second shot, and so he could have become the initial aggressor in that delay when he chose to make the second shot. If there are no more questions, I would rely on the briefs.
Thank you, Mr. Lawton.
May it please the Court. I'm hoping to make a couple of points. First, Your Honor, let me answer your question. The prosecutor, during closing argument, made several references to the whether or not my client was the one that provoked this. In particular, on page 335, he talks about my client starting the fight or saying, let's fight. And then most importantly, on 383 in the rebuttal closing argument, the prosecutor specifically tells the jury the use or threatened use of force is not justified if Mr. Donaldson is the one that provoked the incident. That's the law. You can't start something by saying, let's fight. So he is clearly telling the jury, disregard the self-defense defense because he's the one that provoked the fight. Again, if there's not objective evidence to support that, that's an erroneous argument, and it was an erroneous instruction. So the state's assertion
I'm sorry, why is that an erroneous argument?
Because if there's not evidence to support that my client was the initial provoker under a reasonable standard, then arguing that to the jury, saying, hey, disregard his self-defense defense, that wouldn't be accurate because there's...
He's misstating the evidence, not that he was misstating the
Well,
law.
at that point, the judges agreed to give the instruction, so clearly he had the green light to make that argument, that the judge specifically told both parties they could make this argument. I think the error was when the judge agreed to give this instruction. So going back to harmlessness then, the state's argument essentially is, wait, give the instruction every time, or even if it's erroneous, if there's no evidence to support it, then the jury's just going to disregard it. So they basically would say in every case, regardless of whether there was evidence to support it, if you give it and there was no evidence to support it, then the jury will disregard it and there's no harm. That can't be the law for a couple of reasons. It can't be the law because this is not an instruction that's given in every case. The jury instructions specifically say give if applicable, and obviously cite to the Gibbs case. But beyond that, the reason it becomes confusing is when there's not objective evidence to support it. If there's a clear-cut case, so the case that Your Honor wrote, I believe it's Johnson, no, Moore. Moore is the case where there was a clear conflict in the evidence. And the defendant in that case said, wait a minute, I wasn't the aggressor. But one of the victims said, no, he pulled up to my house, pulled up to my apartment and got out and started shooting. There's obviously conflict in the evidence, therefore a reason to give the instruction. And in that situation, the jury, when given that instruction, they will know that the evidence in the record that one witness specifically said he got out and started shooting, that's why you would be applying.
Well, counsel, I mean, I don't understand. You say that it's got to be aired just to give an instruction when it's improper. I understand that, but if the jury agreed with you that there was no evidence to support the instruction, why couldn't it make that determination? Why couldn't it say, well, there's no evidence that they were the defendant was the initial aggressor? Therefore, we should look at whether he was acting in self-defense or not.
Because they're not equipped to understand why that's even being given when there's no evidence to support it. So
the instruction says clearly what
if you find
to
that he is the aggressor, then he's not justified. But they're not equipped to figure that out if there's not evidence in the record to support it.
So the instruction is insufficient on its face?
When you don't have evidence to support it, yes. Again, that's if there's evidence to support it, the jury can properly weigh that evidence to make a determination. But otherwise, the jury's being told if you find he's the initial aggressor, if he provoked this, well, they're thinking, oh, well, he didn't do a good job putting in the AC vent, and he went outside and he said, take it across the street. For all they know, that might be sufficient because they're not legal scholars, but from an objective legal, and that's why defense counsel argued during this case, there's a difference between legally provoking and simply provoking. They may simply find that amounts to what would be on the street provoking, but if it's not legal provocation, it's simply not sufficient to give the instruction in this case. I see I'm running out of time. I'd ask this court to reverse for both claims and either give my client a new trial or reverse this down to manslaughter. Thank you.
And thank you, counsel, for your respectful oral arguments this morning. Our second case scheduled for oral argument this morning is Christopher Pretzer versus Florida Department of Law Enforcement, Rick Swearinger, et al. Counsel ready to proceed?
Yes, Your Honor.
Again, counsel, we've allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. We'd ask to reserve 4 minutes for rebuttal.
So noted, Madam Clerk. You may proceed when you're ready, counsel.
Thank you, Your Honor. Your Honor, Eric Friday on behalf of the plaintiff's appellants, Christopher Pretzer et al. Your Honor, there are three primary issues that this court must address. The primacy of the legislature to create causes of action and establish the law of the state, FDLE's contradictory claims regarding the firearm purchase process and right to due process, and the ongoing failure of FDLE to comply with the express statutory requirements of 790-065 to give one of 4 specific responses, not some response they made up, and not refusing to give one of those 4 responses in a timely manner. As to the first issue, the legislature...
Counsel, before you get started, it sounds like you are arguing to us what your lawsuit alleged and that you sought relief for, whereas the order that's before us is an order granting judgment on the pleadings for the very narrow reason that your client failed to exhaust administrative remedies before bringing this lawsuit. Can we resolve that question without going into detail about whether FDLE's rules violate the preemption provision of 790.33?
Yes, Your Honor, and then that's why the first issue I said was the primacy of the legislature to create causes of action and establish the law of the state. The legislature in 1987, the legislature passed a preemption law. It was ignored throughout the state. In 2011, it created penalties for that preemption law and, according to this court's opinion in the UNF decision, added state agencies to the grounds of preemption and said that state agencies can now come under 790.33 and may be sued in a court, not in an administrative proceeding. And then in 2021, it reiterates this once again. So just after the release of the Thrasher decision, and again, the Thrasher decision was on very narrow grounds as to the specific administrative process designated by the legislature.
How do you reconcile your argument with the Thrasher 2 decision?
That's what I'm addressing, Your Honor, is that the Thrasher 2 decision was a very narrow decision that focused on Chapter 1001 and the specific new requirement by the legislature to the Board of Governors to create new administrative processes. However, after Thrasher 2 was released in March of 2021, the legislature again amended 790.33 and said, a voluntary change by an agency or any other entity to a regulation, measure, directive, rule, enactment, order, policy, written or unwritten, promulgated or caused to be enforced in violation of this section, with or without court action, the plaintiff is a prevailing plaintiff for purposes of this section. Your Honors, the legislature's use of the words plaintiff, the use of the word court, the use of the word defendant, the use of the word complaint, all indicate a challenge in a court of law. They didn't use petitioner, respondent, administrative hearing, administrative judge. In the context of Chapter 790, when the legislature wants the 120 process to be used, they say it. They specifically tell Department of Agriculture in 790.06.
Can't Thrasher 2 be distinguished as well? In Thrasher 2, there's a specific rule that's been challenged, and here your argument is that this isn't a rule challenge.
Well, that's the other issue, Your Honor, in this case, is that there was no rule for us, the rule that was in effect at the time this action was brought, the plaintiffs take no issue with that rule. That rule tracked perfectly the language of the statute and said that FDLE would give one of the 4 statutorily required responses, and they were giving them. But they quit following that rule.
Well, your argument here, we're not challenging a rule.
Correct.
We're challenging the unwritten policy you've implemented.
Absolutely, Your Honor. We have no issue with the rule, either the one that was in effect at the time the suit was brought, or in the multiple changes FDLE has made to that rule since then, because none of the rules that they have enacted contradict the statute, which says give these 4 responses.
Well, change gears a little bit. Can you bring a class action in a Chapter 120 proceeding?
No, Your Honor, I don't believe that you can. Those are all individualized proceedings, and we're dealing here with tens of thousands of Floridians. We never even got the opportunity to brief the class issue or to seek class certification because of the procedural history of this case. But no, Your Honor, there's no way for this action to be brought in an administrative proceeding. And that goes back, Your Honors, to and again, on judgment on the pleadings, we must take the facts as alleged in the complaint as true and accurate. And there's record evidence in the form of an audio CD from a phone call with Mr. Pretzer and FDLE that FDLE was not offering any type of administrative remedy. No election of rights were sent out. No opportunity for substantial interest hearing were allowed. And this is backed up by the litigation between FDLE and another case, that of Leonardo Lynch, that this court has had, I think, two opinions on. One as to mandamus of having to force FDLE to even render a decision with the agency clerk in that case. And then once the agency clerk rendered a decision, this court had to, FDLE came to this court and argued that Mr. Lynch didn't have any rights under 120 as to the denial of a firearm purchase. So in that case, they say there's no administrative remedy for a person denied a purchase. In this case, they don't offer any administrative remedy to a person who doesn't get any response, but tell them they have to go file a rule change against a rule that there's no problem with. It doesn't matter what these plaintiffs do. FDLE does not want to be held accountable for its conduct and its blatant ignoring of state law. And that is why I addressed that issue, why I also addressed that issue in the brief. Because one of the exceptions to the doctrine of exhaustion of administrative remedies, which I remind the Court is a court-created doctrine that I think and believe that the legislature by this language has said should not apply in these cases. The exhaustion of remedies does not apply when an agency is clearly and completely outside the bounds of its legislatively delegated authority. I think it's important that
Before you make
yes,
that
sir.
point, counsel, I think I've discerned from your brief two different arguments regarding exhaustion. One is that because there is no administrative remedy available, there is nothing to exhaust. And conversely, you're saying that you're entitled, that there's an exception to exhaustion because they're acting, they have no colorable law for their authority. Which of those arguments are you making, and is there a difference between the two?
Both, Your Honor.
So the second one is conceding that you have to exhaust, but there's an exception?
No, Your Honor. I wouldn't concede at all that we have to exhaust. Number one, I believe 79033 says we don't have to exhaust. I believe that the statute itself, the defendants tried to rely on 934. That is the general grant of a rulemaking authority to FDLE. Okay? That's what they cite in their brief. They don't want to talk about Chapter 790. In the context of Chapter 790 and the background check process for firearms, they're no longer under the law enforcement aspects of their rulemaking authority under 934. They're now in an administrative ministerial position of they must conduct a background check and they must give a response. That's what 790.065 tells them to do. Do the background check, give a response. 790.065 specifically tells them develop rules for these things. Review and correction of criminal history records when somebody challenges that the record is unclear or that the criminal history record isn't accurate, give a process for challenging that. If make up rules for acceptance of electronic payments, make up rules for the privacy of the information. They have rules for those. They're allowed to have rules for those. But the legislative grant of those three specific rules, combined with 790.33, combined with, and read imperial materia, are that FDLE's rulemaking authority ends at those three rules. They're not allowed to go any farther. Now, if they want to make, to the extent they had co-regulating rules that said we'll give one of these four responses, we didn't take issue with those rules. When they deleted their obligation in the rule to issue one of those four designated responses, we don't take issue with their rules. But to allow this agency to continue to ignore the express language of the statute, to claim in one case that administrative remedies don't apply in the firearm purchase realm, and in this case say, but you have to file a rule challenge even when we are not giving a substantial interest hearing, flies in the face of justice and denies access to the courts to these plaintiffs that was promised to them by the legislature, and that authority of the legislature is consistent with this court's ruling, again, in UNF decision.
Counsel, generally,
Yes, sir.
can an exhaustion of administrative remedies requirement coexist with statutes that create jurisdiction in the circuit court?
In general, possibly, Your Honor. In the case of 790.33, it cannot, because let's take this example. If we follow the language of 790.33, especially with the 2021 amendment, if these plaintiffs were to bring a rule challenge and they file that rule challenge and FDLE voluntarily quits what it's doing, the legislature's made clear in 790.33 that it wants people to be able to file suit and the agency not be able to moot the case.
Isn't that contrary to what we said in the Thrasher decision? Didn't we explicitly say in that opinion that 790.33 and 1001 706 could coexist? I think that's what Judge Lewis was getting at.
In that case, Your Honor, as to could 1001 exist in conjunction with 790.33 and with 1001 being the later enacted statute? Possibly, Your Honor. Yes, possibly in that case. In the case where the later enacted statute has made clear that these penalties are to be applied and that the agencies are not to be allowed to moot them, and the specific use of clear language by the legislature of complaint, court, plaintiff, defendant, rather than other language. If the court says you must exhaust administrative remedies, I think you eviscerate the meaning of the 2021 amendments, and I think you also fail to apply the language as set forth by the legislature, the body that makes laws for the state of Florida.
Well, I mean, certainly they can coexist, and it depends on the facts of each case. So let's talk about this case. Here, you're seeking damages.
Yes, Your Honor.
So I think going back to Judge Winokur's question, if you had to go back to 120, what could you get at this point? That's really the point to me.
And as to these 10 plaintiffs, Your Honor, that's exactly the point. There's nothing, these 10 plaintiffs are, I believe it's 9 individual plaintiffs, 9 out of the 10 were eventually approved.
Right. You file the pleadings, all of a sudden everything clears up. So is it a bootless journey to go back and say you got to go through the administrative process? Because at this point, you're seeking only damages. Is that even a remedy you could get through that process?
It's not a remedy we can get through that process, Your Honor, and I think that goes back to the judicial efficiency question. Part of the logic behind exhaustion of administrative remedies was for judicial efficiency, and where the remedies are not available in administrative agency, why make people go through the process of getting a judgment declaring that it's invalid and then have to go to court to seek the damages? That doesn't make sense, and it throws the whole stated claimed purpose of exhaustion of administrative remedies on its head. And I'm in my rebuttal times, Your Honor. Thank
Counsel,
you. Yes, sir.
This case, we will extend your time by an additional 5 minutes. We will also extend the appellee's time by an additional 5 minutes.
Yes, sir. Thank you.
You may proceed, Counsel.
Thank you, Your Honors. May it please the Court, Jeff Slanker, along with my law partner, Matt Carson, for the appellees in this case, the Department of Law Enforcement, and Rick Swearingen. And, Your Honors, what the plaintiffs have alleged in this case, and of course we take the complaint here on a motion for judgment on the pleadings in the light most favorable to the plaintiff and based on their allegations. What they've pled here is something that is what we submit is squarely within the confines of Chapter 120. And I want to start by pointing out something that we put in our brief, and there was a little bit of contention on it in the reply brief. We submit that from a standard of review standpoint, the question of whether the plaintiff should be required to exhaust administrative remedies before first seeking circuit court intervention is measured by an abuse of discretion. We've cited the Tropical Trailer case. I believe that was a 3rd District Court of Appeal case, standing for that proposition that the decision of the circuit court to say, whoa, you're putting an issue before this court that should be within the confines.
Aren't we reviewing an order granting judgment on the pleadings?
Yes, Your Honor.
And is that reviewed for abuse of discretion?
What I would submit, Your Honor, is the underlying decision in terms of whether a plaintiff should be required to exhaust administrative remedies. That decision, that should be measured by an abuse of discretion standpoint, and that's what the Tropical Trailer
So
case
the
said.
court could have come to either conclusion, either said that you were required to, I'm sorry, that the plaintiff was required to exhaust, or that they were not required to exhaust. Either way, as long as they don't abuse its discretion, we affirm.
Well, Your Honor, I think that it speaks to what a number of the cases speak to is that the exhaustion requirement is not necessarily jurisdictional, but it's a requirement that is jurisprudential, that it's a matter of judicial discretion in terms of whether it's more appropriate to hear a dispute in the first instance in the circuit court versus requiring the resort to administrative remedies where there is a remedy available, where that provides an ability for the dispute to kind of crystallize itself in that administrative process. So to the extent, and I know there's some legal issues here, what Mr. Friday argued is that 790.33 completely displaces Chapter 120 in any administrative remedy. Maybe that legal issue might be subject to de novo standard, but kind of the underlying determinations about whether it's appropriate to exercise jurisdiction, that's an abuse of discretion call. So I understand what you're saying, Your Honor, in terms of wasn't it resolved on a motion for judgment on the pleadings, and to the extent that that resolution turned on a pure matter of law, and I think that issue that's implicated by the Thrasher case, that might be one of those scenarios. That would be subject to de novo review, but not necessarily the decision of is it proper under this doctrine of, that's really a jurisprudential doctrine, similar to maybe standing and things of that nature, whether it's appropriate to exercise jurisdiction. We'd submit
Counsel, regarding the exceptions,
Yes.
counsel for the appellants argue that they are seeking, or were seeking, damages in the proceedings below. Do appellants have an adequate administrative remedy?
Your Honor, I believe that there's an adequate administrative remedy. I believe that there was an adequate administrative remedy when the case was filed. When the case was filed and when all of the appellants were added as plaintiffs, they had not had a firearm purchase approved. And that was something that could go to Chapter 120. To answer your question directly in terms of damages, yes, Your Honor, the appellants here are seeking damages. They are saying we're entitled to, and what the statute says, it's under 790.33 3F, that plaintiffs that are, I think it's adversely affected by a rule or a policy that's been promulgated and enforced, are entitled to actual damages. Now, let's say that there's no remedy for that in the administrative process. It's insufficient, and we would submit it's insufficient to just say, we're entitled to damages, we can't get that through the 120 process, we should be entitled to go to the circuit court in the first instance. Because I think in almost any situation that you
Well, it's really
might
not the
confront.
first instance. You know, I think you made an interesting point that when the complaints were filed, the background checks were still not answered. We still had decision pending. After the complaint was filed, all of a sudden, everybody's cleared. So now we have a change in the case where damages is the only relief being sought. So surely you're not saying that they have to refile the complaint to then remove the exhaustive, administrative remedy option to go straight into circuit court. All cases change, but if we're only dealing at this point with damages, at the time the trial court is looking at this issue, and you cannot get damages in the administrative process, how can we argue you can't come to circuit court, you've got to go back and seek a remedy that is unavailable?
Well, Your Honor, what I would say is, and this is what the circuit pointed out, is that the recitation of damages in this case was really threadbare. And what we would say is they've not carried their burden in terms of the pleading standard in the state of Florida, which is, of course, a fact pleading jurisdiction, to actually show entitlement to any type of actual damage as defined in the statute. There's some generalities that some of the counts have in terms of, well, folks should be entitled to recover their actual damages, but what are those actual damages as a result of the delay? It's not been established in the complaint, certainly not under the fact pleading standard, that they suffered.
Wouldn't that
any
be
damages.
another phase for that they have to carry their burden to prove up damages in the trial court?
Well, Your Honor, I think that it speaks to the pleading burden because, and this is really, I think, what makes the questions here a little bit more difficult in terms of the record and how the record's been developed, because I think what my friends on the other side have said, and again, I don't want to speak for them. Mr. Friday can correct me if I'm wrong on this, but their approach has always been 790.33 does not or can stand alone, and that 120, the provisions of 120 do not have to be exhausted before resorting to the circuit court. Because what the cases say and what the case law says is you've got to plead in your complaint that you've exhausted administrative remedies or plead that an exception has been established. So what I would say, Your Honor, is that burden's on the plaintiff to say, yes, there's an administrative remedy out there that's ostensibly available. It's Chapter 120. We either utilize that process, we utilize that procedure, or that procedure isn't available to us because of X, Y, and Z. And maybe X, Y, and Z is we've suffered damages. But they've not pled that they've suffered, to the fact pleading standards in the state of Florida, that they've suffered actual damages in their complaint. There's one plaintiff, only one plaintiff, that says, well, when I was delayed, I hired a lawyer, and I paid the lawyer a fee to kind of help resolve the process of the background check. That's not an actual damage. It's at best, maybe a consequential damage, and I would say there's a distinction between the two. And kind of engaging in a thought process in this case, Your Honor, as I was thinking about this issue, I thought about, well, what would be a scenario, right, where there's a situation where there's an application of a preempted law, or a regulation, or a rule that resulted in some actual damage. And I came across a case. It's Sumter County School Board, it's Forest Service versus Sumter County School Board. I can find that site for the court. But in that case, what the dispute was all about was the school board had a rule. And the rule was something along the lines of, you're not allowed to maintain a firearm in your vehicle on school property. And the school board rule said you can be subject to termination if you're an employee for violating this rule. And in that case, what one of the teachers did was they brought a case under 790.33 for declaratory relief, saying, hey, I'm under a cloud of uncertainty here. I want a declaratory relief that this rule is in violation of the broader statutory framework that the Florida legislature has preempted. What that court said, what the court said in that case, both the circuit court and the appellate court, was that there were no actual damages because the teacher in that case wasn't terminated. His employment wasn't terminated. But that might be a scenario where, here's a direct damage as a result of the application of a preempted rule. So, Your Honor, I apologize. That was a long way of answering your question, which is, I don't think they met the pleading burden, and I don't know that they met the fundamental pleading burden of saying, this is why the exceptions do not apply. And that kind of gets back to, I think, what has been the repeated argument in this case, and that's that 790.33 is different. And it's different in that it was meant to kind of push any kind of administrative process, any type of administrative proceeding to the side. And we submit that that's simply not the case. My friends on the other side, Mr. Friday, he talks about the plain language of the statute, that you can bring a complaint, that you can sue, that you can bring suit. But the statute in 790.33 isn't as broad as they say, and it certainly doesn't displace or nullify, which is the language we used in our brief, the Administrative Procedure Act. And what you'll see in the statute.
This isn't just a case that says that you have a cause of action against an agency for X. In that situation, I can see that, maybe there's an exhaustion requirement. This is different than that, it seems to me. This is a preemption issue. This is legislative preemption. They're explicitly saying that the agency is not entitled to do what they are claiming that they have a right to do. So I don't even understand how the administrative process could even address that. Is there any case that says that an administrative agency can address a question of legislative preemption in the first instance?
That a circuit court can, or that an agency can?
That an agency can, because that's what going to DOA means. It means you're going through the agency.
Sure. Yeah, I understand, Judge. I understand, Your Honor. Here's what I would say to that, and I think this is how I read the language to require or still put those administrative remedies at play. And what the statute says is except as otherwise provided by general law or the state constitution. So there's an exception there built into the statute in terms of what the legislature is preempting. And they talk about, too, the legislature, I believe this is in subsection 2 of 790.33, that it intends to displace any and all regulation except state and federal. So I think that there is an acknowledgement in the statute that certainly with respect to state agencies, that there is this process available through Chapter 120 in order to put some of these issues in terms of, is there a preemptive conflict at all before the administrative agency to resolve in the first instance and to allow an agency to create a record and explain its interpretation to aid further judicial review. And I think this is really evident and plainly evident in the exceptions to 790.33. There in 4, I think it's 4D, that says explicitly that nothing in the preemption statute should prevent the exercise of jurisdiction by an administrative law judge. So I think that's an express contemplation that there's going to be situations where
Isn't that really more for situations like in Thrasher, where there was, in fact, what does the statute say, an express provision of authority for rulemaking? In other words, 790.33 doesn't apply at all if there is express authority for rulemaking. And that's essentially what we found in Thrasher. And in that case, of course, an administrative law judge can make findings. I don't know that that sentence tacked on at the very end of 793.3 means that administrative law judges have sort of plenary authority over this issue.
Well, Your Honor, I wouldn't say that they have plenary authority. I think it's evidence of contemplation by the circuit court that there would be by the legislature that there would be circumstances in which resort to administrative remedies.
Right, and Thrasher is one of those circumstances.
Thrasher is one of those circumstances, and I think if you look at Thrasher, here was what the authority that lied in the university in that case. The university had a grant of authority that said it can regulate firearms on campus. General grant of authority, but what this court said was...
If I can correct you, I would say that's a pretty specific grant of authority.
Well, they had authority to regulate that area on campus, and what this court said was there's a process, an administrative process, and a process that is a feature of the state university system in terms of exhaustion and challenging rules, and that process, we've put this in our papers, mirrors really the Chapter 120 process. And what we have in this case is a similar grant of authority. The Department of Law Enforcement has been tasked, it's been instructed under 943.04 to promulgate rules and regulations to carry out duties and responsibilities that have been placed on it under statute. And the responsibility...
Doesn't that kind of swallow all of 790.33 if you say that just sort of a general grant of authority to regulate and the rights contained in Chapter 120 mean that 790.33 is excluded? What's left of 790.33 if that's enough to regulate in spite of the statute?
Your Honor, I think that that grant of authority, along with the task and responsibility from the legislature in 790.065 to the Department of Law Enforcement to implement the background check system, is certainly enough to give it authority to regulate in this instance. And you say, or I appreciate your question, you say, well, what is left, right, of 790.33? And I think that there are scores of different scenarios where 790.33 would apply. Maybe you've got an agency that issues some type of rule or regulation that has no authority at all to regulate in the area of firearms. Maybe you've got, and this is just an example that I'm thinking of off the top of my head, it might not be super artful, right? But maybe you got the Department of Transportation, and they say, well, we are charged with keeping interstate highways safe, or something to that effect. And they issue a rule and they say, well, because we have authority to keep interstate highways safe, you can't have a firearm when you're traveling on the interstate highways. Well, they've not been given any authority to regulate in the area of firearms, maybe tenuously with respect to, some broader notion of safety, but that's unlike.
For that kind of hypothetical, I'd expect Mr. Friday to say, yeah, we probably would have to do the 120 for dealing with a rule, but we don't have a rule challenge here. There's no rule that's being challenged. So those hypotheticals to me don't kind of fairly fit squarely within what we're dealing with in this case.
And well, Your Honor, I appreciate the argument that we don't disagree with the rule. I think that what Mr. Friday had said in some of the briefing was maybe the current iteration of the rule they don't necessarily agree with. I think regardless, what the plaintiffs have available to them is a challenge under 120.56 subsection 4, which is the challenge an unpromulgated or unadopted, rule through the administrative process. And that's what happened in the City of Pompano Beach case, which is cited in our papers. It involved regulation of the Department of Agriculture to address citrus canker down in South Florida. And what the Department of Agriculture did is they implemented this policy that said, we're going to institute a 1,900-foot buffer zone. And what that meant is that if there was a tree, an orange tree, a lemon tree, what have you, that was exhibiting evidence of citrus canker, then they could they could destroy any trees within the 1,900-foot radius. They tried to bring that case, the challengers tried to bring that case directly in the circuit court. And what the circuit court held, or what the District Court of Appeal held, was that has to be exhausted through the administrative process. And what they pointed to was 120.56 subsection 4, the ability to challenge policy as an unadopted rule. And had that process been employed here, then they could have utilized that to get a change in the rule, to have rulemaking instituted if they believed that it was based on an unadopted policy, and to challenge that as an invalid delegation of legislative authority. I'm almost out of time. I just wanted to say that.
Before you finish up, counsel, does the absence of an explicit exhaustion requirement in section 790.33 remove the requirement altogether?
Is the absence of a specific exhaustion requirement?
Yes.
No, Your Honor, I wouldn't say that it does at all.
Why not?
And with that, I conclude. Thank you, Your Honor.
Why or why not?
Oh, I'm sorry. I didn't understand your last point there, Judge Lewis. It wouldn't because, and it's what this case held, or it's what this court held in Thrasher. There's an administrative process available, and the language of section 790.33 can certainly stand together with the requirement to exhaust those administrative process, irrespective of whether the legislature put some specific language speaking to administrative jurisdiction in the statute. And we'd submit that the statute expressly purports not to displace general law, and expressly purports or contemplates that there would be instances in which administrative law judges would have jurisdiction to render a decision under those, what that might arise under that statute.
As I understand the appellant's argument, they're saying the gist of their cause of action is a preemption issue. On the other hand, the argument is that the gist is an administrative issue dealing with an unadopted policy or a rule challenge. How do you respond to those 2 points?
Well, Your Honor, I would say that Thrasher governs. I would say that this court's case in Thrasher exactly speaks to this. And what this court said in Thrasher was, can these 2 concepts of an allegation of a preemptive conflict from an agency that has some authority to regulate in this area, can that stand alongside the allegations of 790.33? And what this court said is it can. And I think that Judge Long's concurrence in that case kind of really drives home part of these points. And what Judge Long said was, look, we've got an agency that has some authority to regulate here, and we've got this broad preemptive statute. There's a rule, there's a regulation. There appears to be some conflict and some tension between the 2, maybe a preemptive conflict. Well, this is something that can benefit from the administrative process. Allow an agency to create a proper record, explain its interpretation, explain its rationale, and that can provide a complete and a full record for a district court of appeal under 120.68 to make those statutory determinations. But what my friends on the other side want to do is put that issue at the forefront, when really that's an issue that should squarely be within the administrative process.
One more question, counsel.
Of course.
There is a similar case pending in this court of Carano, I think I pronounced that correct, versus Swearingen, case number 21-3863, with similar issues. I think the same counsel is involved in both cases, as this case as well. What effect will a written opinion in that case, either affirming or reversing the trial court, have on this case?
Your Honor, it's hard for me to say, obviously, without knowing what the opinion would say and the contours of the opinion. I think the issues are, some of the issues are similar. I think that there's some differences. So I apologize. I'm not trying to be coy or anything like that. I don't necessarily know what the result would be. I believe that exhaustion in both instances and under the facts of both cases was appropriate and required. And my friends on the other side have made very similar arguments in terms of, at least with respect to the preemption issue and the interplay of the preemption issue with the concept of exhausting administrative remedies.
Assume that's the same issue asserted in the other case. What effect will an opinion on the merits of that issue have on this case?
Your Honor, on that issue in terms of whether 790.33 and the administrative process can coexist, I think if this court were to say that they can, and that 790.33 wasn't meant to displace this broad remedial scheme that was enacted by the legislature by implementing Chapter 120, I think that would compel the same result here. And I think that that's what the result was in Thrasher, that, you know, this notion that 790.33 is so broad that it essentially nullifies the requirement, the jurisprudential requirement to go to an available administrative remedy, exhaust an administrative remedy, that it just simply doesn't reach that far and doesn't reach to the extent that the appellants are arguing.
Thank you, counsel.
Thank you.
Counsel, before you get started, there's something that kind of occurred to me that I looked up before about whether, now I know that the agency claims that this is nothing more than a rule challenge, which is typical for, you know, bringing before the Division of Administrative Hearings, and you have denied that. You've denied that this is a rule challenge. But at various points in argument in this case in the briefs, you have, in fact, said that rule does violate 790.33. I have one that FDLE is acting outside of its statutory authority in promulgating and enforcing the rule. That's from your brief. And that the rule improperly attempts co-regulation in an area of express field preemption. Those are both from your brief, and they both seem to strongly imply that what you're doing is challenging the rule, which is exactly what the agency is claiming. Is that the case, or isn't it?
No, Your Honor. The reason those comments are included in the brief is in the case of an express field preemption by the legislature, even co-regulation is prohibited. However, in this case, the rule that was in effect at the time that the plaintiffs attempted to purchase firearm and at the time that they filed this suit, the rule in effect exactly tracked the statute. In other words, had the agency complied with the rule that they had in effect at that time, they would have issued one of the 4 statutorily required responses. They chose not to do so. They chose to operate for a time under an unwritten policy or regulation that nobody knew they were operating under. They didn't issue some official agency statement beyond they started issuing decisions pending. Something that doesn't exist in the statute and is not
non-rule policy something else that's typically brought in the
I don't know
proceedings?
what. I'm sorry, Your Honor. I didn't mean to talk over. I don't know what to call what they did. There's a case out of Wisconsin that talks about their preemption statute, which is modeled on ours. That talks about a wily legislature chasing, or a hapless legislature chasing around a wily agency or entity. To one of them, tires of the chase, or they exhaust the thesaurus. And the legislature here did a good job of trying to exhaust the thesaurus with every word they could come up with for rule, regulation, order, ordinance, policy, written or unwritten. The scope at which state agencies, I point to this court's decision in the RC case and the 3 related cases to that case. These state agencies have attempted to continue to run amok and ignore the legislature when it comes to the regulation of firearms. This court told all of us in UNF that Article 1, Section 8 of the Florida Constitution explicitly reserves to the legislature the right to regulate firearms in this state. The legislature regulated firearms when they passed 790-33, giving themselves a statutory vehicle to carry out their constitutional mandate. Now, they delegated with very clear and specific instructions to, for example, agriculture. If you deny a license, use the 120 process. They didn't tell that to FDLE, but they gave FDLE the option to promulgate rules regarding the review and correction of criminal history records. FDLE has, in fact, created a process for that. Under 790-065 is their statutory authority, not under 934. And I think it's important for this court to consider the rules that they keep citing to, that they want a rule challenge brought on, that they claim to be authorized under 934. All of those rules at the time that this case was brought claimed 790.065 as the authority, not 934. To address the court's question
Counsel,
about...
as a follow-up to Judge Veronica's question,
Yes, sir.
the trial court noted at page 6 of this order, plaintiffs contend that because they challenge an informal or unwritten policy of FDLE and do not otherwise mention Rule 11C-6.009 by name, the requirement to exhaust available administrative remedies does not apply to their claims. Plaintiffs, however, offer a distinction without a difference. Then, court notes, regardless of whether or not their claims are premised on a formally adopted rule or an FDLE reliance on an unwritten adopted policy, plaintiffs have an available administrative remedy in the APA. Do you agree with that statement?
No, sir, I do not agree
And
with
why
that.
not?
I do not agree with that statement because at the point that we don't have an adequate remedy because the number of people and the financial burden on each of these people to litigate against FDLE, number one. Number two, the putative class actions aspect of this, which would not be allowed. Number three, the lack of damages remedy available from FDLE. Number four, the obligation or the right to bring an action in court, as the legislature said. Number five, the exception to administrative remedies doctrine that an agency acting without any colorable authority in promulgating even an unwritten policy, rule, or regulation is one of the exceptions that allows the case to be brought in circuit court. In this case, Your Honor, they have not once in their briefing before this court, nor in oral argument today, did these appellees make any claim that they are authorized to give a response other than the four statutory responses. At no time did they claim that the rulemaking authority allowed them to give something other than the four statutory obligated responses. And in fact, their own rule, as they have modified it throughout this litigation, still does not attempt to claim the right to give anything other than the four statutorily mandated responses. And that's why I believe that this court should find that they have acted completely outside the bounds, ultra-virus, and outside of any rulemaking authority they have in relation to regulating firearm purchases and background checks by failing to apply those four responses. And once the court says that answers the question that administrative exhaustion was not required in this case, and this case should be remanded. And I would ask the court to remand it with instructions that FDLE shall immediately start giving the four responses as the statute requires. Nobody is above the law, not even the state agency that is a law enforcement agency is above the law, and they should be compelled at this point to issue the four responses they were told by the legislature to issue.
What are your clients' damages in this case?
Your Honor, my clients have suffered damage every day that they were denied the right to purchase a firearm. The court may value that as a nominal damage of $1 or $100, but nominal damages are actual damages where a constitutional right has been denied to somebody. And now we're getting into questions of constitutional law, but 790-33 clearly states that it is intended to prevent.
But you haven't brought your complaint as a constitutional claim, have you?
No, sir, I have not, because 79033 states that its purpose and intent is to deter, prevent, and eventually remedy deprivations of constitutional rights enacted by these agencies or cities or counties against the legislature's authority. And that is in the complaint,
Is
Your
the
Honor.
assessment of fees and the refunding of those fees at issue in this case?
The refunding of what kind of fees, Your Honor?
Just a question. Is that an issue in this case?
Of the background check fees? No,
Yes.
sir, Your Honor, it is not an issue in this case. This case is brought because solely on the issue of people who were denied their right to partake their firearm within 3 days after, and it depends on if we're talking about state or federal law, there's a slight conflict, 24 working hours versus 3 business days. We would agree that the federal statute is going to control because it's slightly longer, but these people were denied for months and in some cases years. There are still people being denied every day at the rate of approximately 1,800 people a month by this agency because it refuses to comply with the express language of 790-065, which is to issue one of 4 responses and to issue them within 24 working hours or 3 business days.
Counsel, this brings me back to what I think is the very first question I asked you. You've stated a lot of remedies that you think we should remand to the trial court to grant your clients. But again, this is a review of an order granting judgment on the pleadings. So what remedy do we have available to us, even if we agreed with you and your client, other than to reverse the order and remand for reconsideration of your complaint?
Your Honor, as the issue is set, as it sits before this court, the proper thing for this court to do at a minimum is to reverse the lower court's finding regarding exhaustion of administrative remedies and to remand for further proceedings. And of course, at that point, we would be able to file for an injunctive relief in the lower court. However, at this point in this case, I believe that the issues have been sufficiently briefed before this court and sufficiently before this court on the issue as the judgment of the pleadings that the agency is clearly violating state law. The agency has offered no explanation in its briefing or oral argument to substantiate why it should be allowed to continue, and I think this court can make a finding based on the record before it that the agency is not issuing the 4 required responses and should immediately comply with statute. I don't think that's a huge remedy or ask. It's not asking for a full declaratory judgment. It's merely a question of whether this court has the power to remind the state agency that the law says what it says and the court expects that agency to comply with that law. Thank you.
And thank you, counsels, for your respective oral arguments this morning. This concludes our oral arguments for this morning. We are adjourned.
All rise.